So in Illinois, we call it allocation of parental responsibilities and not custody because people used to argue over custody. But allocation and custody are the same thing. It's about decision making. So when you're talking about allocation or custody, you're talking about decision making. And when you're talking about parenting time, you're talking about the time you're actually with your children. So in Illinois, we have the best interest factors, and those are several factors that are written out, and there are a variety of things a court will consider when making these decisions. For example, children's interests and their wishes is one of several factors. So a lot of times people think that at a certain age, the child gets to make those decisions. They don't. We look at the child, the parents, the community, a variety of other factors in determining what's in the child's best interest. Okay, when we're talking allocation, you're talking 4 major decisions. In no particular order, you're talking religion, extracurriculars, healthcare, and education. So sometimes the court will look at all those different best interest factors, but they may look at some other things, such as, let's say you've got one parent that's in healthcare and better equipped to make healthcare decisions. The court may allocate that. Same thing with education if you had someone that's an educator. The court can look at any factor it wants when making these determinations. So I can tell you from a practitioner standpoint, so having done this, I can tell you that joint parenting is more common than it, say, used to be, but there's nothing in the law that says that Illinois presumes that we're going to do joint parenting. We presume that parents are fit to be parents, but we don't always presume that it's going to be joint parenting. So when it comes to parenting plans, it kind of breaks down into 3 components, really. You've got your regular parenting time, which is the school year. Kids are in school most of the time, so that's going to be your regular schedule. Then you're going to have holiday parenting time, and you're going to have breaks. So think your winter break, spring break, summer break. These are going to be how you break things down. You're going to look at the parent schedules. You're going to look at the kid schedules, look at the distance between the parents. You're going to look at a variety of factors and ultimately come up with a plan that makes sense. Okay, when the parents can't agree on custody or parenting time, there's no exact formula of what's going to happen. But some things you're likely going to see is going to have a guardian ad litem appointed on behalf of your children. That person kind of becomes the eyes and the ears of the court. They'll kind of do investigations, ultimately make some recommendations to the court. The reality is your case is either going to end with either you and your spouse reaching an agreement or the judge is going to make a decision. If you guys cannot agree, the judge is going to do everything they can to gather information to make the best decision possible for your children. So obviously, if there's domestic violence or substance abuse problems, that's going to have an impact on the decision here. Because if one parent has problems, certainly a court's going to be looking at the other parent if possible. So when it comes to a child's preferences, I always tell parents, we don't want to put that kind of pressure on a child, nor do we want to give that child that much power. In other words, you flip the dynamic if they get to make the decision. So in Illinois, the child's preferences are weighed, but they don't get to make the decision.